welcome everyone, and thank you for joining us in this third session on our series on remote work, this time covering EMEA. Before I hand this over to our panelists, I just wanted to go over a few quick housekeeping things. You have been muted upon arrival, and I do ask that you please remain so throughout. This will be a quick 30-minute session, so if you do have questions, feel free to drop them in the chat, and if we have a chance to get to them at the end, we will. We'll do our best to do so, and if not, we will follow up with you via email, so we will make sure to get your questions answered. The session will be recorded and will be available on our website next week. If you missed the previous two sessions, we did one on the Americas and on Asia. You can find both of those in the Knowledge Center on theworldlawgroup.com under recordings. So with that, I'm going to go ahead and hand this over to our EMEA co-chair of WLG's Human Resources Group, Gaël Choupard of CMS Belgium.
Thank you very much, Anna, and welcome everybody. I'm pleased to be the leader of the session today, and we have also guests and very nice speakers today. So maybe I will present myself very briefly and present all speakers today. So I'm Gaël Choupard. I'm the head of the employment team in Brussels. I'm working in employment law since 22 years. I'm the co-head of the EMEA practice within the World Law Group. I will be assisted today by Anja Neumann, who is working at CMS in Germany. I will be also assisted by Philip Schmidt, who is working at Arendt and Luxembourg. And I will be assisted by Fabien, who is working at Soulier in France, Paris. So welcome everybody, and thank you, Anna, Philip, and Fabien for having agreed on attending to this webinar. So let's go and jump into the subject. We are talking today about the digital nomads. So what is a digital nomad? So we have taken the focus of a foreign worker coming from a foreign country and coming to work in our jurisdiction from an entirely remote perspective. So the first question, and it's a general question. So does a remote workers need a work permit in your jurisdiction? In Belgium, the question is quite easy to answer. So each foreigner, so which by foreigner we mean non-EU worker who wants to work in Belgium, including on a 100% remote basis, must obtain what we call a work permit and an authorization to stay. Is it the same in Germany? Anja?
Not exactly the same. So employees coming from the EU member states or from the European Economic Area and Switzerland do not need a residence or work permit. However, employees and also digital nomads from third countries do need a residence permit that also includes normally a work permit in order to work here on German territory.
Fabien, in France, what's the situation?
It would be kind of the same as in Germany. A non-EU member will be required to have a work permit and a residence permit for him to work on French territory. Okay,
so Fabien, another question: is there a specific visa or work permit for that type of category of employees, or for people working on a remote basis?
It can be actually for people who will be able to justify a specific knowledge. This is what we all know as EU members as a blue European card, which will not oblige the foreign employee to have a work and residence permit. For other employee of lower level, the situation of employment in France could be opposed to someone who has no specific skills or knowledge to authorize him to come and work on French territory.
Okay, thank you. Philip, what's the situation in Luxembourg?
Well, what we have seen so far, Gail, is that basically you need to distinguish two situations in Luxembourg. The one being the digital nomad staying outside Luxembourg and working for a Luxembourg company. So no physical presence in Luxembourg. There would be no residence permit at all, and no specific residence permit, of course, for the digital nomad. Now, if this person comes to Luxembourg and works in Luxembourg, from Luxembourg territory, we have not yet seen in Luxembourg legislation a specific residence permit. So I guess that the law should need to be updated based on the recent developments of digital working, which has increased quite a lot. But so far, we are still sticking with the old categories of immigration. And as Fabien mentioned, we also know the system of the European Blue Card or the standard employee, but unfortunately, no additional flexibility whatsoever for nomad workers so far.
Yeah, but so I think we are all on the same basis for all different countries, so no specific work permit for that kind of employees, which is not the case around the world. So I know that in Asia and some South American countries, they have a specific work permit for what we call digital nomads, and so it's easier for them to have access to this specific market and to to work remotely under the sun during the winter. So, but not in Germany, not in Belgium, and not in France for the moment. Do you have any idea if the length of the stay could impact the requirement to obtain a work permit? So in Belgium, it doesn't has any impact on the work permit. Of course, on the visa, it's a little bit different. So you can always come in Belgium with a 90 days visa, but in principle, you're not authorized to work. So it's in principle just a touristic visa. How is the situation in Luxembourg, Philip?
Well, we have the same, Gail, then that in Belgium, of course, we know this visa for like a 19 days period where you are not supposed to work. You could work if you get the authorization of the Ministry of Foreign Affairs, but basically you're not supposed to work under a short-term visa. Now, if you secure a residence permit, the rule is the opposite. Basically, you need to be in Luxembourg and carry out your work in Luxembourg. So if you have a residence permit, you need to be in Luxembourg at least 6 months per year. And we have seen an increasing appetite also of authorities to verify this and to control whether people are actually staying in Luxembourg or not. So we have quite recently handled a few files where the ministry has asked digital nomads to prove that they have been staying in Luxembourg. So they had to produce evidence of payments that they did in Luxembourg, their phone bill, gas bill, electricity, whatsoever. So every mean of evidence is acceptable, but you need to prove it. So the advice that we give digital nomads is really to secure evidence about their stay. So if there is a control in any country, that you need to evidence how long you have been staying in the country, that you are able to evidence this.
Okay, that's interesting. Fabien, do you have the same kind of control or requirement in France?
Not the same as Luxembourg. The regime would be quite comparable to the German one and the Belgian one, which means that the length of the stay will not affect the authorizations to get for a foreign employee to come on French territory. Here, not talking about EU members, of course, but just foreign employees outside of EU scope.
Okay. So another topic that is quite another topic when we are talking about digital nomad is the tax and corporate implication for the employer. So our clients in Belgium very often raise the question of the tax implication. So do we need to withhold tax? Do we need to comply to Belgian law? Do we need to subscribe to some administration to register ourselves as an employer? So as for the moment, there is no exemption in Belgium. So you're basically employing a foreigner in Belgium. Even if you are a foreign country, you're obliged to subscribe or to inscribe yourself as an employer to the Social Security Administration, as long, of course, as the Belgian Social Security is applicable. You're obliged to fill in a specific form that is only applicable in Belgium, which is called a limosa, which is a form that is applicable for foreigner, not submitted to the Belgian Social Security system. And the purpose of that form is to inform the Belgian authorities that, in fact, you are employing someone on the Belgian territory. The purpose of that is to allow the Belgium state to control that you are employing someone within, let's say, the Belgium limits and regulations. So it's quite a very important step to undertake when you are employing someone in Belgium. Of course, depending on the length of the stay, you will have to withhold tax, and you will have also to pay some social security contribution. And of course, you will also have to comply to the Belgium labor law, which oblige an employer to provide to the employee with some labor documents that must fill in some requirements. So Belgium has quite a very strong regulations regarding that aspect. I guess that, Anya, in Germany, you will have the same kind of regulations.
Yeah, indeed, it's similar. So the corporate-related implications have to be assessed on a case-by-case basis, of course. So, for example, if a German company employs someone abroad, that is possible directly, meaning without a subsidiary or a branch. If the same is possible the other way around, meaning if someone is employed in Germany by a foreign country, it needs to be assessed by the law of the foreign country, of course. From a tax perspective, the main risk for foreign employers is that digital nomad may be viewed as a permanent establishment under the tax law of Germany. So that means a permanent establishment would give the foreign employer a taxable presence in Germany, triggering additional tax obligations. This is something clients are usually quite interested in, and we also have this problem, of course, the other way around. As regards social security contributions, it's basically the same. So if the digital nomad is working more than 25% of his or her time in Germany, speaking of a 12-month period, then he or she will most likely have to pay social security contributions in Germany. And from a contract law perspective, is basically the same like in Belgium. So we have the regulations within Rome 1. So there might be some mandatory rules that need to be checked. For example, working time requirements. But apart from that, within Rome 1, you are free to decide on the contractual basis.
Indeed. The question of the permanent establishment is quite on the topic also when we have clients who are employing people in Belgium, especially when we are talking about salesperson. So very often we have US-based companies sending one or engaging one salesperson in Belgium, working from in home office and visiting clients, and that of course is a let's say a hot topic for them, because very often if we are speaking about a salesperson working in Belgium, you have a huge risk of permanent establishments, which means taxation in Europe. And for US company, we know that they do not like that. So Fabien, what's the French perspective on that topic?
In France, we do know the same issue that you guys in Germany and Belgium, with regard especially with tax matters that you just described, Gaël, and social security, which rules are the same in France and Belgium, Luxembourg and Germany. A specific focus may arise with regard to the law applicable to the employee, notwithstanding the law that would be applicable to the contractual relationship. Let's say that a foreign employer employs a foreign employees to come to France and to work on French territory, even though his working employment contract is subject to, let's say, US or UK law. Public order, which are mandatory laws in France, may apply by preference to any law provided by the contract, especially working time, which is a huge matter in France, and which can often trigger some frustrations from clients who would be eager to have a salesperson, let's say, work 45 hours per week, and which is not possible under French law, when mandatory law, French labor code regarding working time applies to the working relationship, because working time regulations in France are mandatory and have to supersede any foreign provisions of the same nature. So this is quite an issue when we know of foreign employees working in France, even though they are subject to a foreign law applicable to their work employment contract.
Quite interesting. But also we have the same principle applicable in Belgium. So mandatory law, even if you choose the application of another law, Belgian mandatory law will apply. But it's always, so in Belgium, always possible to find some, let's say, derogation in the Belgian law to avoid the application of, let's say, all these strengthened rule. So we have a specific status of personnel of trust, of personnel of management, and these kind of person are exempted to be or are not obliged to comply to the working time regulation. I guess that you have approximately the same kind of regulation with the forfait jour in France, that's correct?
Yes, unfortunately, the forfait jour has to be provided by an applicable CBA, which is not automatically applicable to one employee and one only, when the employee is the only guy who's working on behalf of a foreign company which has no presence in France. And this is the problem we know here. The forfait jour won't be applicable to this only employee.
Problem for the digital nomad if he's
Yeah.
alone. So in Belgium we have a distinction between person who are coming on a employee basis or self-employed person. So basically in Belgium, these two categories of employee exist. What's the situation in Luxembourg, Philip?
Yes, we have the same situation over here. So basically, when you apply for a residence permit or any kind of other immigration documents, there is a clear distinction between self-employed person and employees. And that's also the same in labor law. We see that the labor code makes a distinction between employees and self-employed persons. We know that there are some countries out there who are thinking about a third category of employees, notably those working for digital platforms, so so-called platform workers. But so far, we don't have this in Luxembourg. So it's very black or white, and the same goes for immigration. And I can just say, based on our experience, that it is much easier to immigrate as an employee as opposed to a self-employed person, because if you immigrate as a self-employed person, you need to produce a business plan, and you need to show that your activity will succeed, and basically that the figures are speaking for the success of the undertaking.
What is the situation in Germany, Alia?
Yeah, in fact, it's similar. So in both cases, the digital nomad has to obtain a residence or work permit. However, if you look into the detail, there are quite some differences. For example, if you're entering Germany as an employee, the residence permit is usually granted for 4 years, whereas as a independent contractor, it's granted for 3 years maximum, and we have the same requirements as Philippe said. And we also, of course, have a clear distinction under German law between employees and independent contractors.
Is that the same situation applies in France, Fabien?
Yes, quite. For an employee, it would be always easier to get a residence and a visa to authorize the employee to work, whereas a self-employee would have not only to get a work and residence permit, but the work permit will have to be assessed on the viability, the economic viability of the business that is intended to be carried out by the self-employed who is applying for the authorization to perform his business project in France. So not only a visa will be necessary, but also the demonstration that the economic project is viable and is real to get the authorization to establish in France.
Quite interesting to know that In fact, in each of our jurisdiction, it's easier to get a work permit as an employee than as self-employed, and we understand easily why. Because if you apply for a self-employed work permit without a, let's say, project with some content, of course, everybody will apply for this work permit, and it will be a mess. So let's say, keep in mind that for employees, it's easier. For self-employed, you have to provide business plan and to show that your project will bring something to the economy. So let's go to the last question. So we are talking about these digital nomads, and very often indeed these digital nomads are working for a company located abroad. But what about, let's say, digital nomads who are working for a company located abroad, but who has this company has a presence in your jurisdiction? Does it change something in your country? What's the situation in Germany, Anya?
So if the employee is employed directly or not, it doesn't really make a difference. So as soon as a third country national is working from German territory, there will be a need to obtain a residence title or work permit, irrespective of the question whether the company has a presence in Germany or not.
Is it the same situation in Luxembourg, Philip?
Yes, definitely. And that's a question that we see quite often because, as you may know, Luxembourg is not a large country. So there are a lot of companies having employees in Luxembourg, but not necessarily a presence here. So not necessarily offices here. And we have seen with the pandemic, this has been accelerated. So a lot of companies employing employees in Luxembourg for any personal convenience reasons the employees may have. So they might choose based on their personal situation to prefer working from Luxembourg, even if the company doesn't have a presence here. And it doesn't really make a difference. It's just that you consider those persons working full-time in a home office setup, basically. But from an immigration perspective, it doesn't make a difference at all. Exactly the same. It's just for the company, the foreign company employing an employee in Luxembourg, which needs to undergo the administrative formalities here in Luxembourg to affiliate, for example, the employee with Social Security. But it's the same situation as if they had a presence here in Luxembourg.
It's quite exactly the same situation in Belgium, except that if you have a company or a presence here in Belgium, it's quite a little bit easier to obtain a Belgian work permit. Why? It's because in order to apply for a Belgian work permit, you need to have a Belgian representative in Belgium, which means a Belgian national or someone who is authorized to stay on the long term in Belgium. So very often when we have a foreigner company based abroad without any presence in Belgium, you need to find someone who is ready to take the risk to apply on your behalf for a work permit, which means that it can involve some consequences if you apply for a company who does not respect Belgian law. But sometimes we are ready to play that role for our good clients. So, Beth, I think that's the end of the different questions that we have planned to discuss today. So if we have any question, we are ready to answer. I don't know if Beth or Anna, do you have received any question during the webinar, or do the attendees have questions right now?
Hi, Gael, this is Hannah. I don't see any questions from the audience, but if you have them, you're welcome to either drop in the chat, or if you prefer, you can send me an email and I will drop my email address into the chat and we can get those answered for you. But with that, Gael, I think that if we don't have any questions from anyone that's joined us or anything else that you wanted to ask our panelists, I think we can wrap up today.
Cool.
All right, as I mentioned, this webinar will be available on our website as a recording next week. You can find it in the Knowledge Center under recordings, and we encourage you to share this with your colleagues. We did a session last week on the Americas and the week prior on Asia, so this wraps up our 3-part series. I would like to thank Gael, Fabian, Philippe, and Anja today for this quick session on remote work, and hope everyone has a great day or evening wherever you are. Thanks, everyone.
Thank you.
Thanks, everyone.
Thank you all.
Thank you, Anya. Thank you, Philippe. Thank you, Fabian. Bye-bye.
Thank you all. Bye.